Dear students, today we are learning probation system in the administration of criminal justice in India. I am Professor Nirmal Kanti Chakraborty, Director, School of Law, KIT University, Bhubaneswar. I did my PhD on probation system in the administration of criminal justice in West Bengal, a critical appraisal of the system. Today, to begin with the module on criminal justice and probation system, I will present to you how probation system is integrated with the criminal justice administration, and in this process we will learn in our criminal justice administration what are the legal provisions which govern our criminal justice system and probation system, and also we will look into how the criminal justice administration probation is interlinked, how far it is being implemented in our criminal justice system. In this module, we will learn admonition in criminal justice system, we will learn probation system in the criminal justice system, we will learn probation in plea bargaining, we will learn also how probation being incorporated and being applied in juvenile justice system under the Juvenile Justice Care and Protection of Children Act 2000. If we look into our criminal justice administration and in the background of probation system, we have to go back to basic concept of correction and punishment, that is whether punishment or sentence should fit the offence or the offender. So, let us look into our criminal justice administration and probation system, how it is working. The first question is, what is probation? To understand probation, let us take two fact situations where courts in India put their mind how to apply their discretion. One fact situation, it happened that a woman having chronic disease husband in the bed, no other alternatives, no way to livelihood, selected a job or a vocation for carrying illegal liquor from a village where illegal liquor being manufactured to a town, and she was apprehended by the police, ultimately before the court. Court is to decide whether to send her to jail or to go for correction through probation system. Court granted probation, and in granting probation, court put into the fact situation and use its discretion. In other situation, a young boy having marriage of her sister 3 days after, having no other alternative to arrange the money for the marriage of her sister, took some money from the cash as he was the cashier, and after the marriage the office handed over him to the police and he admitted the guilty. The court was on dilemma whether to send him to jail or to go for benefit of probation. Court granted probation. So, probation in fact a conditional suspension of sentence, whereby a procedure established that court may release an offender on probation of good conduct for a certain period, maximum 3 years, and on fulfilling that condition without committing further crime, he may be released permanently without going to jail. So, it is a sentencing process. it is a discretion of the court, and conceptually it can be discussed, it is discussed with three different theory. These theoretical explanations are: first one, grace or mercy theory. In grace and mercy theory, the concept of probation described that it is a benefit, it is an advantage, a privilege, a mercy given by the court on certain conditions. On breaking or violating that condition, that mercy would be withdrawn. That means probation order be revoked. The second theory, which is being described by the follower of contract theory, is this: in probation, the probationer has to enter into an agreement that he will observe all the conditions put by the court, and he will obey the orders of the court, and failure of that orders, like breach of contract, he will also have to face the penalty. Like in contract, breach of contract means there would be imposition of penalty. Similarly, in probation, if the probationer failed to observe the contract or the conditions which he agreed to observe, he will also again go to jail and face the penalty. The third concept of probation is custody theory. In this theory, it is believed that any probationer, when released under benefit of probation of good conduct, he is under the legal custody of the court. So he has to obey the court orders and conditions. On breaking of any condition, court will revoke that probation or benefit, and he will also be sent to the prison for violation, and he will not be given the freedom, conditional freedom, which was extended. So which was extended to a probationer, that probation system, when came to our legal system of the world. If we go back to the history of probation, it is also a voluntary zeal of one Boston cobbler, namely John Augustus. In 1841, in USA, in Boston town, John Augustus one morning saw that a person in the court was crying and asking him to take on bail and promising that he will not take again drinks or alcohol if he is being freed from the correctional home. Augustus took him on bail, and thereby he started to take the offenders who committed very minor offences and put under his supervision. When he died in 1958, there are more than 2000 such probationers were under his supervision. Thus began the probation system, and John Augustus being treated as father of probation system. But during the same period, 1841, another magistrate, Matthew Davenport Hill, Warwickshire Quarter Sessions in UK, claimed that probation was his concept or brainchild. He discontinued even one-day jail within the court, and even pardon in the court itself at the time of sentencing. But probation in its true sense, in the sense where the offender is to undergo a supervision, that really came through the voluntary works of John Augustus. If we look into the legal aspect legal origin statutory probation that starts in 1878 in Massachusetts, USA, where a probation officer was appointed from the police, and he was under the supervision of the court to look after the person released on probation of good conduct. In UK also, first statute on probation came in 1879. But if we look into our Indian legal system, we can say that first seats of probation started in our Criminal Procedure Code 1898 in section 562, which now in our Criminal Procedure Code 1973 under section 360 of 1973, the same provisions being followed by Indian courts. But the statute on probation, the law which governs probation system in the country mainly, is the Probation of Offenders Act 1958. But why probation? Is it an alternative to imprisonment? Let us try to get the answer. If we look into Bentham's philosophy of punishment, theory of punishment, Bentham started that we should look into the evils of punishment also. So reformation, where possible, we have to think, because all punishments are evil in itself. So reformation of offenders has its objective value from 19th century onwards. Moreover, if we look into the statistics, it is revealed that probation is less recidivism than imprisonment. In imprisonment, the prisoners' recidivism rate in India varied from 5 to 6, whereas in probation it is within only 1 or 2%. Moreover, to avoid overcrowding in prison and community correction, probation can be taken as our most accepted form of correction or punishment. Present trends is non-institutional correction, and to that sense, probation is also welcome to our criminal justice system. And finally, there is inherent self-correction process for which probation is very much essential in criminal justice administration. If we look into Indian legal system and Indian laws, there are varied processes of probation in India. Under section 3 of Probation of Offenders Act 58, there is a provision of admonition, which is a verbal warning to the offenders. There is provision of section 4 in Probation of Offenders Act, a system of probation where offender can be released and extended benefit of probation, which may extend to 3 years, and if no offence committed, he is not to go to jail or to have any other punishment. We have also from 2006 amendment of Criminal Procedure Code under section 265E, within plea bargaining there is a provision that if the parties to the plea bargaining agreed to have probation as alternative to any punishment, the court can grant that extension of probation to the offender. We have also in our Juvenile Justice Care and Protection of Children Act 2000 the system of probation. Under section 15E and F, provision of probation provided for juveniles who are in conflict with law. let us look into what is admonition. Section 3 of the Probation Offenders Act, as we have already learned, provides the provision of admonition, which is a verbal warning or condemnation on minor offences. And who can get that? First offenders, circumstances of the case, considering circumstances of the case, the court can think, also the nature of the offence and character of the offender. Particularly when offence be one of the following descriptions of IPC, like 379 theft, 380 theft in dwelling house, 381 theft by clerk or servant, 404 misappropriation of the property, or 420 cheating under IPC. And any other offence, if punishable with imprisonment for not more than 2 years, or with fine, or with both, under Indian Penal Code or under any other law for the time being in force, the court can grant admonition, court can release the offender by verbal warning. Now let us look into circumstances or cases where admonition granted by court in India. Very first case where principles of and guidelines of admonition declared by court, we can look into BC Kishan Sona versus State of Odisha, where the judge categorized the classes of cases or circumstances where court can grant admonition. For example, in case of Sitaram Sali versus State of Maharashtra, the Supreme Court, in a case where an employee of a railway convicted for committing theft of coal worth ₹8 only, convicted and dismissed from service, the court held that he may be treated under section 3 or 4 of the Probation of Offenders Act. Similarly, Anil Kumar Pandey and another versus State of Bihar, where two brothers on a dispute of their property and land demarcation involved certain quarrel and also caused injury, the court granted the benefit of admonition under section 3 of the act and dismissed the trial court as well as the high court's conviction and sentencing to jail. Now if we look into the probation under section 4 of the PO Act, the first thing we have to remember here, unlike admonition, except offence which are punishable with death or life imprisonment, any other offence either in the IPC or any other special legislation except Prevention of Corruption Act, any offender can be considered by the court for release under probation of good conduct under section 4. And what the court will look into? The circumstances of the case, character or antecedents of the offender, age of the offender, and also the pre-sentence investigation report or PSI report submitted by the probation officer. And to use this discretion, how the court in various situations applied the principles seen in section 4, we may look into few cases. In Ved Prakash versus State of Haryana, the Supreme Court held that wherever there is a provision of giving or extending benefit of probation, the court should not act mechanically. Court should look into the circumstances of the case and extend the benefit of probation instead of sending the offender on jail. In Saradakar Sao versus State of Odisha, the Odisha High Court observed that for standing or by trespassing land between residence and a temple, a very minor offense, for that probation is the fit punishment for the offender. Similarly, in Amini versus State of Kerala, the Kerala High Court observed that where a woman having husband and the sole earning member carrying illegal liquor and convicted under Abkari Act is a fit case to be released on probation. But in state of Maharashtra versus Kapurchat Kesarimal, where the young offender carrying huge quantity of gold, or Dalbir Singh versus state of Haryana for accident under section 304A, or in Sanjeev Nanda versus state of NCT, where there is attempt of kidnapping, or Gitaram another versus state of Himachal Pradesh, where the offense was showing of blue film to young generation. The court held these are not fit cases for extending benefit of probation. In fact, if we look into various cases, it can be identified there are some mitigating circumstances for granting admonition or probation by the court, such as age of the offender, economic condition or means of livelihood, first offender or offense committed spur of moment, or provocation, temptation, absence of bad intention, or self-preservation or preservation of nearest one. Similarly, if we look into our JJ Act, where children are involved in offences, there are provisions that juvenile to be released on probation under care of any parent, guardian or any fit person, or under care of any fit institution, and if both things fit, the child can be given under supervision of a probation officer under his jurisdiction. But sentencing of a young offender, there is a provision in section 6 where it is mandatory on the court to write or explain why the young offender below 21 years of age not granting probation, or why the court refusing probation to the convict. Under this, we may refer some cases where the court insisting to look into provision of section 6. In Ishar Das v. State of Punjab, court held that where the young offender was below 21 years of age, the trial court should look into why the benefit of probation not being granted. Similarly, in Srimati Moni v. State of Kerala, the court held that it is mandatory on the part of the court to extend the benefit of probation to the offenders if he is below 21 years of age. But in Sadek and another versus of West Bengal, where at the trial stage no question of 21 years age was raised, the High Court in Calcutta not granted probation on the ground it was not raised in the trial stage. In Municipal Corporation of Delhi versus State of Delhi, the court, however, granted benefit of probation because of the age of the offender was below 21 years of age. But the more controversial section now in Probation of Offenders Act is section 12, disqualification attached to conviction. Section 12 says that where an offender released under section 4 of Probation of Offenders Act any disqualification attached to the conviction would not affect the offender. If we look into some cases where Supreme Court in various cases varied its principles. In Shankar Das versus Union of India, the then Chief Justice Y.B. Chandrachud held that where a government employee being convicted for parking scooter in no parking zone, he should not be removed from service and is a fit case to extend benefit of probation, and if as he is given benefit of probation, he should not be dismissed under Article 311 of our Constitution. And our framers of the Constitution not thought that for parking in no parking area of a scooter, an employee should lost his job. But in Tikaram versus B.K. Seth, another, the court overruled the earlier Shankar Das versus Union of India, and dismissal of the service from the service by a government employee on conviction under their service rule been upheld, and that is followed in Horichand versus Director of School Education. But again in Ved Prakash versus Union of India, the Supreme Court held that benefit or disqualification attached to conviction includes that his service should not be affected for giving probation under section 4 of the Act. Similarly, Lalman Verma versus Punjab State Power Corporation Limited, again in 2012, the Supreme Court held upholding the Tikaram, returning to Tikaram principle, that conviction in any way the government has right to dismiss or remove him from service. In fact, if we look into the various decisions of the Supreme Court, there is a question of interpretation of section 12 of the PO Act. It is based on traditional attitude. Traditional attitude means that in our interpretation of penal statute, normally strict principle of interpretation being followed. But if it is against the legislature, if it is against the legislature, in that case we have to think, because there is a principle, intention of legislature predominates. What is the intention of legislature in passing Probation of Offenders Act? If we go to the minutes of the dissent's meaning, where it was raised on section 12, that section 12 is essential for rehabilitation. So it is a contrary interpretation from the intention of legislature for which the Probation of Offenders Act, particularly section 12, was inserted. And there is ambiguity, and whenever there is ambiguity, the penal statute principle says it should be resolved in favor of the convict. So it is against the principle of rule of interpretation which the Supreme Court in various cases decided. If we look into reformation of the offender and removing him and from the service, these are two conflicting principles. So this aspect requires and demanding review of the Supreme Court on its various judgments. As we have noted that probation also we have in plea bargaining. In the plea bargaining is a process whereby the accused and the prosecutor in criminal case work out a mutually satisfactory disposition, and in the process of disposition, if after accepted guilty or there is a conviction, the court can accept or grant probation as within the plea bargaining process. And in the plea bargaining process, public prosecutor, investigator, the accused and the victim, if all agreed, the probation can be granted under section 265E(b) of the Criminal Procedure Code. But the soul of probation system soul of probation system is in our self-correction process. An empirical study in West Bengal reveals that majority of probationers are illiterate, unskilled workers, they are poor, agricultural laborers and of rural background. Also, there is no intensive supervision of the probation work, as one probation officer is to work 3,253 square kilometer area, where no intensive supervision is possible. So, where no intensive supervision, no rehabilitation process, and all are poor, in spite of that, study reveals 70% ex-probationers have been leading to a normal life without any rehabilitation programs of the probation department. In fact, it happened because probation system has an inherent efficiency of self-correction, whereby by getting that opportunity, the offender realized he is wrong. He is giving the opportunity to think that yes, he has given an opportunity to correct himself, to return to normal life. And probation system working for last more than 150 years in not only Indian legal system, throughout the globe, because of its inherent efficiency. So, probation as a system is a very effective system. The question is in efficiency. Efficiency level varied from place to place, but probation as a system having its efficiency, inherent self-correction process, this self-correction made the probation as part of criminal justice administration. So, criminal justice administration probation is very much essential in the sentencing disposition. Without correction, the object of punishment to help the offenders or the convicted person to return to normal life would have been impossible. At least part of the selective offenders need this probation, and that is why probation is in all the countries' legal system.